In my last video, I have discussed about the topic of nikah or marriage under the Muslim personal law. What are its objects and what are the essential conditions required for a valid nikah. Now, I was left out with the provisions that is called impediments or prohibitions, which will make the marriage invalid, or you can say it is a void as per the Sunni or the Shia school of law. Now we have to see what are the impediments which will affect the validity of the marriage. That is, there are four impediments are there. First impediment is the polyandry. Now polyandry, there is a two term is here. One is a polyandry and another is a polygamy. A married woman cannot contract of second marriage during the subsistence of first marriage. So the women are not allowed. So they are restricted to have more than one husband. If suppose the first marriage, the first husband is alive or she was with her husband, she cannot go for second marriage, that is a second husband. That is called polyandry. But polygamy, as per Hindu Marriage Act, it is a crime. So it is prosecuted under the CRPC. It is an offense, criminal offense. But polygamy, as per the Muslim personal law, it is allowed. So that is, polygamy is allowed up to the four wives. So husband can have more than one wife. So it is permitted. But polyandry is not permitted at all. Now second impediments or the prohibitions is the consanguinity. What is a consanguinity? There is some blood relation is there whereby you cannot marry within this relations. That is why we say this is an impediments or the prohibitions, that is known as consanguinity. Now what are the blood relations? You cannot go for a marriage. Now prohibition on the ground of consanguinity is a prohibition to marry some of blood relations. The relations with whom a Muslim male is absolutely prohibited from marrying are. So Muslim male is prohibited here. We are talking about Muslim male. And that is not that conditional. That is absolutely, there is no condition about it. Absolutely he is prohibited to marry this. Now what are the relations? First is an ascendance. When you say it about ascendance, it is always an upward direction, that is how high soever. So he cannot marry his mother or his grandmother. Then second is a descendants. Descendants means how low soever. It is going downward directions, downward relations. So his daughter and the granddaughter he cannot marry. The third is his sister, full or uterine. He cannot marry with his sister, whether she is a full or uterine. And the fourth is his niece or great niece. He cannot marry. Then his aunt or great aunt on both father's and mother's side he cannot marry. So marriage on the above mentioned ground is prohibited, and that is why that prohibition will turn into the nikah or the marriage will be void. That is batil we call under the Muslim law. Now the third impediment is the affinity. Now what is affinity? A man cannot contract a valid marriage with his wife's mother or sister or among close relationship. So he cannot marry with his mother, sister or among close relationship. So a marriage which is prohibited by reason of affinity is void. So this relationships, if he get married, then that nikah or the marriage will be void. That is called batil. So a Muslim is prohibited from marrying with all such relatives who are close in affinity are. Who are close in affinity? Wife's mother or grandmother. That is how high soever. So these are the relatives who are in affinity. He cannot marry his wife's mother or grandmother. He cannot marry his wife's daughter or granddaughter, how low soever. Now here is a question arises when you talks about a wife's daughter or granddaughter. So don't you think that the question arises here that don't you think the daughter, wife's daughter means it's not his daughter? It is not his daughter? What is the answer? No, actually we are talking about legitimacy and illegitimacy. If suppose his daughter, then he could have said directly you can make the provision that his daughter. That's why we are saying wife's daughter or granddaughter. That is, that daughter may be illegitimate. That is why she might be in the custody of a wife. So that's why we said it is a wife's daughter or granddaughter. Then son's wife or son's wife. So how low or soever. So he cannot marry with his son's wife or son's wife. So the woman who cannot marry with her daughter's husband, it will be void. So a woman cannot marry with her daughter's husband, then it will be void, that is a batil. Now, the next impediments or the prohibition is the fosterage. What is fosterage? So the meaning fosterage, everyone knows that who will be rearing up by the lady, not his or her own mother. So this is called foster. So now we are going to see what the fostering relation is. So if a person has been brought up by a lady who has provided milk to both the children, that means that a boy and a girl who has been brought up by a lady who has given a milk to her or his, like similarly with the children of her own. So this is called fosterage relations. So it is accepted by both Shia and the Sunni school. So now what are the foster relations? The foster relationships are first marriage of father of a child with mother of his child, foster mother. So father of a child means father of a child cannot marry a mother of his foster mother. That means the son who has been brought up by the lady, not his own mother. So the same father cannot marry with this lady because she is in the relation of foster relation. Then with her daughter, foster mothers. So he cannot marry with his daughter, foster mother. So you cannot have a marriage with these foster relationships. If it is married within these relations, those marriage will be called as a void marriage or it is called batil. Now the formalities of a Muslim marriage or the nikah. Now what are the formalities we require to have the nikah or to have the marriage? So nikah is done in presence of two witnesses and qazi assemble at one place. Now we require to have two witnesses and there must be a qazi assembled in the meeting. So qazi must be present in the meeting, because why we require to have the qazi? The qazi is the one who will have the nikah nama. In that nikah nama he will sign. So that's why qazi will read out the nikah nama in front of both the husband and wife, or the proposer and the acceptor. That is ijab made by one person and qubul made by another person. So that is why qazi must be assembled in one meeting. So the proposal and acceptance of a marriage must be expressed in one meeting. So the one meeting means in the same meeting they has to express the proposal and qubul to be made in one meeting. Not that proposal is made today and tomorrow they fixed up for acceptance to be made by the girl, no. In the one meeting only, they has to express their consent. The Qazi prepares the Nikah and it is duly signed by the witnesses. So in that same meeting, the Qazi will prepare the Nikah and it will be signed by the witnesses. So the Nikah must mention about the prompt payment and the way in which the deferred dower shall be paid. Now the dower has to be paid in the nikah. So how to be made and what are the types of dower to be made, it should be mentioned in the nikah nama. Whether it is a prompt, that is prompt means immediately making a nikah, the husband should give a dower to the wife immediately, or it will be given in future date. That's called deferred dower. So that should be mentioned in the nikah nama. That is why Qazi must be present in the same meeting. So these are the four relations that is under the prohibitory degrees, or it's called impediments to have the nikah. If you are having the nikah within these prohibitory degrees or the impediments, then nikah will be void, that is called batil. Now there are other relative impediments are there. We said relative impediments. It is not directly within the prohibited degree, but it is a relatively. You have to take into considerations while dispute arises before the court. Now prohibitions which makes the marriage irregular, that is called fasid. When it will be called the marriage or the nikah will be fasid, that is irregular, how it will be mixed, what prohibitions is made under the law, we have to see. Marrying a fifth wife. If you are marrying the fifth one, then your marriage will be called as a prohibitory. Absence of proper witnesses. If there is no witnesses and witnesses should be proper, then it is called irregular. Difference of religion, Shia, Sunni, if this varies, so then it is irregular. Unlawful conjugation. If it is an unlawful conjugation, it will be also, that is irregular. Then women undergoing iddat. If iddat period is followed by the women, then it will be irregular. Now we are discussing under marrying a fifth wife, one by one we will discuss. So if a man has 4 wives alive and he marries his fifth wife, will be irregular. Then absence of proper witnesses. That means Sunni said if witnesses are not present, that is a proper witness is not present, then marriage will be irregular. But Shia will say that it is not only irregular, it will be void. That difference of religion, then it is the nikah will be irregular. An unlawful conjugation is a Muslim is forbidden to marry 2 women related to each other. So if Muslim is marrying 2 female at a time, but they are related to each other, then it will be irregular. And marrying 2 sisters at a time, the marriage will be irregular on the ground. And lastly, we are talking about the women undergoing iddat. Now what is iddat? So iddat is a marriage with a woman who is under the period of iddat is irregular. Now what is iddat? Iddat is a period of chastity which a Muslim woman is bound to observe after the dissolution of her marriage. Now we have to see here how to follow the iddat. That is also 2 categories we have divided. Now iddat has to be followed if suppose the marriage is dissolved by the reason of the death of the husband and by reason of the divorce, which is court orders, court declaration is made for a divorce. Then how the iddat has to be observed? Now you see that before she can remarry again lawfully, she has to observe this iddat period. So iddat period for death, it is a 4 months and 10 days, and iddat period for divorce, it is a 3 months. So she has to wait, Muslim women has to wait for 4 months and 10 days to go for a second marriage, and because the death is occurred, and that is why her marriage is dissolved, and she can go for second marriage, but she has to wait for this months. And if it is dissolution is made, that is divorce has got it already, then she has to wait for 3 months and then go for a second marriage. So these are the impediments related to the nikah or the marriage under the Muslim personal law, and it has to be followed. Otherwise, your marriage will be void. That is called batil.